I greet you now. This is Arogo Speaks on Arogo Insights. Today, we go talk about romantic promise and legal intent. When you do, I love you, I love you, I love you. Whether you go fit carry that I love you, carry go court and get judgment. And in doing that, we will analyze the breach of promise suit with Doris Ogala, one file against Pastor Chris Okafor. And to get to the root of the matter, we will look at the Supreme Court case of Ezeanah and Atta. Wetin Supreme Court talk for that matter. But before we start, make I tell una say for Arogo Insights, we don dey hold strong policy for long time say we no go dey enter personal matter of big people wey dey public eye, like the people wey dey act films, Nollywood stars, big pastor dem, politicians, and so many other big people. This our way come from say we wan focus on bigger issues, social and political wahala, wey go help people reason well and respect privacy. We no dey follow issues wey dey trend. We discuss issues that we can sustain over a period of time. We believe say personal things, especially love matter and family arrangement, better make dem handle am on private basis. No need to dey drag am for public unless e touch serious legal principle or public interest. But because of the plenty messages and questions wey our dear followers send come, we decide say make we bend small for this one. Plenty of una don reach us say make we talk about this alleged love wahala wey no work between Miss Doris Ogala and Pastor Chris Okafor, plus how she wan find justice for breach of promise to marry and other things. We dey thank una well for una interest and trust for our platform. Na because of this kind community vibe wey una bring, we decide say make we drop this short legal analysis. Make una know say we no dey here to judge anybody or to dey make gossip hot, no. But na to look am straight, check wetin be the chance say this kind claim go succeed, especially when we know say social and family agreements no dey suppose get legal wahala like that. This principle dey from common law and Nigerian law wey we don take am from the common law background wey Oyinbo give us. E dey talk say agreement for personal love matter plenty times no dey get serious intention to make binding for court. We go check all this one with full respect, pull from correct legal cases to give una clear eye and better understanding. Thank you plenty for una support and how una dey understand say we dey handle this matter with care. The katakata wey burst for the love story between the Nollywood actress Doris Ogala and the Lagos-based pastor Chris Okafor dey revolve around her public allegation, all the things wey she come on Twitter live and Facebook live. They talk about the promise wey the pastor promised to marry am plenty times through their relationship wey start around 2017. According to Doris Ogala, the repeated promises make am do big sacrifices like divorcing her husband her former husband, when things dey tough for their marriage, and even transfer 45 million naira give am for one transaction, plus grant am access to her finances because she trust say marriage dey sure. She claim say Pastor Okafor introduce am to im family, including im pikin dem, and then they appear together for family events to show him intention dey serious. But later, the pastor come abandon am, engage and marry another woman wey dem dey call Pearl for December 2025, wey cause am serious emotional pain, health issues like suicidal thoughts. E dey come for her mind to kill herself and panic attacks, plus reputational damage. Her name don spoil as a public figure and actress. The whole matter directly touch the common law doctrine of intention to create legal relations, wey be basic thing for any contract to hold. We don discuss all of these matters before, but make we look at the law as e dey for Nigeria. Let's do a legal analysis. The law say for normal family or love matters like romantic relationship, then get long time presumption wey say people no dey intend to make their talk turn legal binding agreement, as dem show am for the classic English case of Balfour and Balfour. But for Nigerian law, wey still dey follow plenty common law, promise to marry na special case. If evidence show clear mutual intention to enter real marriage, statutory marriage, the one wey dem dey do for court, customary marriage, the one wey we dey do for our houses, or Islamic marriage, the one wey Muslim dem dey do, instead of just sweet mouth or lover talk, then the presumption fit change. The Supreme Court, in the case of Ms. Ezeanah and Alhaji Atta in 2004, talk am clear say for promise to marry to be enforceable, it must leave no doubt as to the real intention of the parties to marry. No doubt, kpata go dey say the parties from the beginning been agree say dem go marry, and dem fit infer this intent. Dem fit know whether the parties agree to marry from how the people dey behave, even if dem no write am with biro and paper. For that Supreme Court case, the appellant, Ms. Ezeanah, wey be banker and managing director of First Bank at the time, and the respondent, Alhaji Atta, start to dey do lovey matter from 1990s. The respondent, wey dey dominate the relationship, give am plenty gifts, including sponsor her studies for England, carry am go Oyinbo, send am better school, rent house for am. They travel from Nigeria, they go visit am for London plenty times. The man fight na about the ownership of one plot of land, plot 999 for Mabuchi district, Abuja. The respondent claims say he buy the land, give am because dem plan to marry. And since she end the relationship, he suppose get back the land. Maybe through resulting trust or say na conditional gift. That one be say, I give you the land, say you go marry me, and so that the land go be our property. Unfortunately, the appellant again come talk say her own outright, the appellant come talk say her own was an outright gift. For the High Court, Then rule for Ezeanah say no enough evidence for binding marriage promise or trust wey depend on marriage. The katakata con go reach Court of Appeal. The Court of Appeal come tamper with some parts of the judgment. The girl no come like wetin the Court of Appeal do to the judgment. The girl come appeal the matter go reach Supreme Court. Supreme Court come finally confirm say the land na the girl own and throw away the respondent's claim totally. The man lost the marriage, alleged marriage promised him, lost a beautiful plot of land in Abuja, lost everything. In that case, Supreme Court come talk say the respondent no bring enough evidence to prove clear mutual promise to marry or say the land dem hold am on trust till marriage go happen. Then use the opportunity clarify the law on breach of promise to marry, say e still dey enforceable for Nigeria, unlike England where they don't stop am since 1970. But that the promise must show clear serious intention to marry. Just love talk, sweet nothings, or normal boyfriend and girlfriend no reach. Dem fit infer the intent from the conduct even without writing. But for this case, evidence no strong enough. This case don't turn big authority on wetin you need to prove for breach of promise to marry. Number one, quanquem, you go prove say clear mutual promise wey pass normal romance. No be to say na my boyfriend, na my girlfriend, no. You go prove say there was a clear mutual, the man tell the woman tell the man, say we go marry. No be when one man dey say I go marry you, the one dey say wait, I go think about am. 2, unjustified breach wey cause lot or pain to the innocent person. When both of them come agree, say dem go marry each other, one come later on come say I no dey marry again. And that thing wey that person talk come cause pain, or the person can lose plenty things. The Supreme Court for Ezeanah and Atta don't become top authority for Nigerian law on how to prove breach of promise to marry. As I talk am before, dem say 2 things wey must dey. 1, a clear mutual promise to do court marriage, the one wey dem dey call statutory marriage, customary marriage, the one wey we dey do for our villages, and Islamic marriage, the one wey Islam dem dey do, wey pass just love, affection, or casual talk. And 2, one side unjustifiably, without any provocation, refuse or fail to do am. Supreme Court still come clarify say intention to marry fit come from how people dey act even without paper, but it must not leave any doubt say dem dey serious. Even though plenty books, all the articles wey big professors dem dey write, and the ones wey small boys dey write for blogs don quote Ezeanah and Atta as the modern foundation of this topic, no plenty reported higher cases after 2004 dey directly cite am for new breach of promise matters wey reach appeal. This fit be say plenty of these katakata cases between man and woman dem dey settle am outside court because of the shame wey some of this talk dey bring. I mean, everyday relationships dey break down. If everybody wey lose somebody wey promise you to marry come arrive for court, the embarrassment, the shame that comes with distilling these issues in the public domain when you carry these kata-kata come talk am for public. I can just imagine the level of embarrassment and shame that is going to both families, the family of Doris Ogala and the family of Pastor Chris. That's why people know they carry these things come court. Or then go handle them for lower courts like high courts or magistrate court where they know they report their judgment. Or they even dismiss them early because evidence they weak. All the same, the principles as enunciated in Ezeanah and Atta still they use for related marriage cases and matters about gifts we depend on marriage. Lower courts, they always make plaintiff meet the standard which Supreme Court set for Ezeanah, like bring strong evidence. We pass just sweet nothings. I love you, I do this, those things don't mean anything. And she'll say them suffer loss because then rely on the promise. Then they reference them for cases about gifts in contemplation of marriage to remind, say, love relationships no dey automatically create legal duty without clear intent. Older cases like the decision in Egbe and Adefarasin decided in 1987 wey confirm say breach of promise to marry is actionable in Nigeria, they discussed together with Ezeanah, but since 2004, courts they use the stricter evidence rule from Ezeanah to separate real binding promise from casual romance. One old case like that one between Uso and Iketu Boson, where people they mention as example, where they award damages after long engagement, shows similar principles, though it happened before the decision of the Supreme Court in Ezeanah. For today, in Nigeria, courts still they uphold breach of promise claims based on the framework laid by the Supreme Court in Ezeanah and Atta. They give damages for proven money loss, emotional pain, or reputational damage when the elements complete, but then they reduce or reject big claims wey dey too much. This Doris Ogala case na 1 billion. 1 billion no be small money. Make we apply the principles wey we get from the Supreme Court in Ezeanah and Atta to wetin happen for Doris Ogala case. Allegations of repeated promises, family introductions, joint events, plus her big reliance, say she divorced her husband, give the pastor plenty money, fit argue say he rebut the presumption against legal intent. The actions fit show say Pastor Chris's assurances pass normal lover talk and create serious intention for binding commitment. If court prove am, e go turn the promise to enforceable contract wey fit bring liability for breach and damages, maybe through promissory estoppel or straight contract remedy. As things stand today, Doris Ogala don send pre-action letter through her letters, Synergy Law Partners, to demand 1 billion for breach of promise to marry, emotional distress, reputational damage, public apology, and more. For Nigeria, breach of promise to marry still dey actionable as civil wrong, unlike in England, where they don abolish am since 1970. To win, Doris Ogala must prove 1. clear mutual promise to marry to unjustified breach by Pastor Chris Okafor, like his recent wedding to Pearl, and 3 real losses wey come from wetin don happen. Public details like a claim of financial transfers, photos, videos, WhatsApp messages and chats, and live changes wey she do because of the promise give some basis for these elements. But the case merit still no dey sure, and it go depend heavily on strong evidence like messages, witnesses, bank records, and documents wey dem go bring for court. The 1 billion demand too big when you compare with normal awards of similar cases in Nigeria, wey mostly dey cover real expenses and small emotional pain. No be like punitive money plus previous public wahala between them, including her earlier accusations and threats, plus recent drama like sharing private photos and reported arrests, even though they don't release her, fit make defense paint am as say she get bad motive or she's not a credible person. Make we finish this matter now. The conclusion wey we dey bring to our followers and our supporters and our viewers is that Doris Ogala matter no be rubbish case and if he reach full trial or settlement, because Nigerian law still recognize breach of promise to marry actions. But to win complete, especially that big money, no dey easy at all. This wahala, this katakata, this saga show how romantic promises fit turn serious legal fight when evidence show clear intention to create legal relations, just as the Supreme Court in Ezeanah and Atta been teach us. I dey thank una well for always telling us where to go to and what to do. We have tried to bring an answer to whether or not the case of Doris Ogala would have merit in a court of law, but that will be dependent entirely on the matrix of the facts and the evidence that will be adduced by Doris Ogala. It is straight law that he who asserts the existence of a thing must prove that that thing does exist. Now Doris, they say, them promise her marriage. Now she go tell the court how them take promise her when it take happen. We dey thank una. Make you no fail to subscribe to our YouTube channel and follow us on Facebook, Instagram, Twitter, and TikTok. May God bless you well. Thank you.